Welcome to Monday Musings in the Midwest. I'm Barrick Collins, your host, and I hope you enjoy this second edition of this new video podcast. We focus on 4 topics: law, education, parenting, and finally, management and leadership. I have experience in all those issues over several decades, so I hope my musings will either entertain you, inform you, or cause you to think. Now, nothing I'm doing today or at any time should be considered legal advice, and we don't have an attorney-client relationship. In addition, when I talk about crimes and trials, unless somebody's been convicted in a court of law, they are innocent until proven guilty. Let's dive into the first area I wanted to talk about today. I got a couple of questions last week after the first video, and so I thought one of them was worth dealing with on its own, and that's the legal concept of standing. No, not standing in your field or getting up from your TV, which I've started to grunt and groan as I do today, but the concept of who can bring a lawsuit, and in court that's called, do you have standing to sue? Do you have standing to bring that case? Do you have standing to bring a criminal case, for that matter? Well, this arose from one of our viewers from last week, and I thank you all who tuned in, and I hope you'll share this, who was asking me about President Trump's proposed $1.5 billion January 5th weaponization fund. In other words, that fund that he wanted to create to compensate those people who were convicted or prosecuted because of their activities on January 6th. Which, by the way, I'm not talking about today, whether you're for it or against it, that's not the issue. But this person was saying, who has standing? Who can bring that lawsuit? In other words, could I bring the lawsuit or could you? Well, standing's a legal concept, and it's really your legal right to bring a lawsuit. There are 3 concepts that you have to make, 3 factors in that. First of all, there has to be an injury in fact. Are you injured by whatever activity you want to bring a lawsuit about? Did I in fact kill your dog? That's an injury to you, right? So you could bring a lawsuit. Did I in fact kill your second cousin's 3rd wife's dog? Probably not, unless of course you were very close to that dog. So injury in fact, were you in fact injured by the events that you want to complain about? The second is, do you have a causal connection? Can we trace your connection to the event? My daughter ran over your dog in front of your house on a street in another city. Can you sue me for that? Well, perhaps you can. There might be a causal connection. Was my daughter driving my car? Was she driving it properly? Did she have my permission? Those kinds of things all go to that causal connection. And finally, the likelihood of redress. Is it likely if you bring this suit that the issue is going to be solved? Now, here's what I've got to tell you about courts. You have a single judge in most cases, and he or she's going to make a decision. When you get to the appellate level and the Supreme Court level, you have multiple judges or justices on a case. And you'll see opinions come out 6-3, 5-4, 7-2, 2-1. In other words, nothing is absolute in the law. And that's one of the things you have to remember as we go through this. So what I think as a judge in that initial level may be overturned on appeal, because 2 of the 3 appellate judges may see it a different way, or 7 of the 9 Supreme Court justices may see it another way. So even if you win at the lower level on appeal, there's a chance you could lose. But is there a likelihood of redress? Now, this came up in the Trump case, and this person said, is there, could I join that lawsuit? Well, you're a taxpayer and they're using taxpayer money. Can you meet those three factors? Can you show there's an injury in fact? Well, if you are a taxpayer, that's taking money from other things that you might find important, or using your tax dollars for something that you don't like or do like, one of the two, whichever way it is. So you meet the injury in fact, I think. Second is the causal connections. Can we trace your injury to this fund? I think that's fairly obvious. You're taking your tax money or your tax dollars, diverting them from one thing and putting them in another. I think there's that causal connection. Is there a likelihood of redress? Well, if the fund doesn't go forward, money may be able to go to a cause that you enjoy, or it may reduce your tax burden. So that's kind of an example of standing, and standing just means, do you have the capacity? Are you a proper person to bring the suit? Have you been injured? Standing's an important concept, and always think about that when you're looking at a lawsuit. Let's dive into a case that's ongoing right now in Texas, in the Dallas, Texas area. In fact, I think it's a McKinney court. So I used to live in Dallas for a little bit. It's state of Texas versus a young man named Carmelo Anthony. And I think it was just last year. It may have been in 2024, but I think it was in 2025. Carmelo Anthony was a 17-year-old, and he was at a track meet and ended up stabbing a young man, also 17, named Austin Metcalf. He stabbed Austin Metcalf in the chest, and unfortunately, Austin Metcalf passed away in the arms of his twin brothers. So let's set the stage. We're at a track meet. If you've been to a track meet, and I've been to a couple of hundred, they're kind of wild affairs. There are a lot of kids running around. Obviously, it's track, they're running. I get it. A lot of kids running around. And schools tend to set up tents in the bleachers to provide some cover for their athletes, provide a place where they can gather all their belongings, provide a place for them to sit out of the sun so they can conserve some energy. Those tents in the track and field environment are kind of sacred. Only the athletes from Anytown USA High School is supposed to go into the Anytown USA tent. Is that legal? Is that an absolute property interest? I don't know. That's one of the issues in this case. Well, Carmelo Anthony, and it's unclear whether he was acting as a track athlete or he was just there in the stands, or if he had been suspended from school. I don't understand that. That's one area to look at. Got under the Memorial High School tent that Austin Metcalf had been part of setting up and was kind of guarding. And he was confronted by Austin Metcalf because they knew Carmelo was not one of their athletes. Think about it. You've got your wallet, you've got your drink, you've got some of your personal belongings sitting in a tent. You might not want other people in that area. There was a confrontation. The witness testimony I reviewed from last week kind of showed that it was a very brief confrontation. And the story that's come out in court so far is that Austin Metcalf and others asked him to leave. The story is they asked him to leave more than 10 times, and that Carmelo had his hand in his bag and said something to the effect, "Touch me and see what happens." Austin Metcalf, we think, reached out and shoved him in the shoulder. Carmelo took a knife out, stabbed Austin Metcalf in the chest, and unfortunately, Austin passed away. Carmelo threw his knife up in the stands, ran off. He was caught by a security guard, and it's my understanding he basically confessed, "Yes, I stabbed the guy." But Carmelo claims he did so in self-defense. Well, let's look at self-defense, and there are 3 elements you have to be aware of. The first was your defense of yourself proportional? In other words, somebody has a wet noodle and they're flipping that wet noodle around. This is kind of absurd, but you'll get the idea. The wet noodle's flipping around. Do you have a right then to pull a gun and threaten them? Probably not. The second is there a necessity? In other words, is there an immediate and imminent threat of great, and that's the key, great bodily harm? Not just bodily harm, not just somebody's going to slap you and it's going to hurt for a couple of seconds, but great bodily harm. I've got a wet noodle. I'm threatening you with that wet noodle. Do you have a right to shoot me? Probably not, because is there a necessity? There's not an imminent threat of great bodily harm. It's the best thing I can come up with. And finally, the third is there a reasonable belief that you could be harmed? There's harm to yourself or to others that are close to you or to your property. Those are the three elements. You've got to meet all three of those. You've got to have a proportional response to what's going on. You've got to have necessity, and you've got to have a reasonable belief that it's going to happen. Now, remember in law, there's this reasonable person fiction that we can figure out what a reasonable person would be. That doesn't mean you're reasonable. It means, is what happened to the general population of reasonable people reasonable? Okay. Then there's another aspect in many places, in many states, and remember the laws vary from state to state. In most states, you cannot be the initial aggressor. Now think about this. He's under this tent. He's told by the others to get out of the tent. And Carmelo Anthony says, supposedly, something like, touch me and see what happens. Does that make him the initial aggressor? You can't be the initial aggressor. In other words, I can't come up and smack you with a 2x4 and then pull out a gun and shoot you because I'm afraid you're going to get up. Another concept, but it's one of those things, if you meet the three elements, we have to look at whether you're initial aggressor. Okay, having said all that, there's also another key concept. Is there a duty to retreat? In the old days, under common law, you couldn't use self-defense, especially deadly force, unless you tried to retreat first. Now, here's where this happens. I'm backed into a corner. You have a knife. You're threatening me. I can't go one way or another. I can't retreat, so I can use deadly force. I'm standing outside. You have a knife. You're threatening me. I have a duty to back away, to try to close the door and lock you out, to try to run. I have that duty to retreat under common law. However, in the past few decades, 30 states, maybe a few more, have passed a stand your ground law, which basically gets rid of that duty to retreat, especially in your home. And it's in your home, it's called the castle. The castle stand your ground. So let's talk about those stand your ground laws. If you're going to stand your ground, you have to have a legal presence. Now, it's unclear whether Carmelo Anthony was legally on that school ground. He wasn't an athlete at the track meet. It is a public place, but it's my understanding he may or may not have been suspended at that time. That's unclear. It's got to come out in the trial. You have to be legally present. That's something to look at for Carmelo Anthony. Second, you can't provoke it in the stand your ground law. You cannot be the provocateur. You can't be the one who says, touch me and see what happens. I don't know in this case who provoked whom. It's a jury question. And finally, you cannot be a part of illegal activity. Now, here's the thing. Knives were illegal on school property. I don't know if there was some kind of 5-inch knives or greater are illegal on school property. All I've seen is that knives were illegal on school property. So was Carmelo Anthony, who is in Texas, a stand your ground state, did he meet all three of those? That he was legally present in that tent, that he did not provoke it, and there was no illegal activity. Now, there is also the castle doctrine. I'm just going to do a little aside. If you are in your home and somebody breaks in these states that have stand your ground laws, many times your home, if they're breaking into your home, a home intruder, you can use deadly force. So the Carmelo Anthony case is going to be interesting because you've got the prosecution saying this young man murdered Austin Metcalf, and you've got Carmelo Anthony saying, I used self-defense. I was afraid for my life. The case is ongoing. The prosecution rested on Saturday. Yeah, you heard me right. This judge wants to get this over. They're going Monday through Saturday. Oh, and did I mention Austin Metcalf was white and Carmelo Anthony was black? There's a racial undertone in this. Be watching for this because it's an absolutely fascinating case from a legal standpoint, and when you can use a self-defense. It'll be interesting to see what comes out. Next case, we talked about a little last time, the education case of Virginia versus Ebony Parker. Again, a 6-year-old brought a gun to school. Ebony Parker was an assistant principal. She was told the young man had a gun. She did nothing. I don't know why she did nothing. They tried to bring criminal charges against her. The judge dismissed those charges as not meeting the basic elements of the crime. There was no intent, in other words, for Ebony Parker to commit a crime of child neglect or whatever it was they brought. Well, I have to tell you that my dog's here. I have a license to be a school administrator, and I would tell all school administrators to kind of look at this case. We are seeing more and more parents being charged with criminal activity because of the activities of their child. Again, we go back to Michigan and the Crumley case where the parents of a school shooter, the Crumley moms in Michigan, were charged with crimes, and now both parents are in prison. In addition to the school shooter, and this was a young man who was a teenager, 13, 14, 15 years old. They were charged criminally with his criminal activities. We're seeing more of that. Are they now going to start coming after educators who don't stop some of these things in advance? Now, I'm going to say in Ebony Parker's defense, I think there was state testing going on. A lot of times states have rules that there must be an administrator located in a certain range. Maybe she was saying, hey, I can't go check this right now because I'm working on this state testing. I don't know what happened, but I think it's scary in the education field for an administrator to be charged with a crime when they didn't act immediately. I think administrators should take a lesson from this. If there is something that appears deadly, we've got a student with a knife, we've got a student with a gun, we've got a student who's threatening somebody with a pop bottle, rock, whatever it is, you need to drop everything, I think, and take steps to ensure the safety of all the other students. So you need to do something because this criminal charge really gave me pause. All right. Couple of questions. One was the standing question that I dealt with earlier. Another person asked me, what's the saddest case I've ever seen? And I'm not going to talk specifically about my caseload. I've seen a lot in my years. I was a prosecutor and a defense attorney, and I've seen some horrible things. But lately, the worst case I've seen was the Athena Strand abduction and eventual demise at the hands of Tanner Horner down in Texas. Did you hear my dog? Tanner Horner was either a UPS or a FedEx driver. I'm sorry, I don't remember which. He was delivering packages to Athena Strand's home. I think Athena was 7. He abducted her and ended up killing her. It's a horrible, horrible set of facts. Tanner Horner went to trial and pled guilty. And so the only thing they had to do was the second stage of that trial. The jury had to find what the punishment would be. And they eventually sentenced him to death. But during the course of that trial, and I don't think Tanner Horner knew that the truck he was in recorded audio from everything. There was an actual audio played of what happened to Athena Strand. And I will tell you, I could not stomach it. I had to do it in pieces. I had to play parts of it and then walk away for a while, and I would come back and play the next part and walk away. It really impacted myself. It impacted others. If you want to terrorize yourself, go listen to that audio tape. It really kind of encapsulates the brutality that there is in the world. But I think I wanted to talk about the Athena Strand case for one reason and one reason alone. If you are called in to be on a jury, you're living your best life, you get that notice, you do your civic duty, and it is a duty to go in and be on a jury, you don't know what you're going to see. And the people that were on this Tanner Horner Athena Strand trial may need some mental health help. I don't think you forget that kind of thing. And it may impact our jurors. And so I would urge everyone to urge their legislatures to set up a fund where jurors who are on these horrible cases can get some help. Well, that's enough for this week. I hope you're having fun with Monday Musings in the Midwest. I'm enjoying it. Again, everybody's innocent until proven guilty in a court of law. I'm not your attorney, and this is not legal advice, but I hope it gives you a reason to think. Until next week, goodbye.